Great, so I think we'll now be able to make a start. Hello and welcome to this Doughty Street webinar on the new immigration rules and guidance dealing with the admissibility of asylum claims and third country removals. I'm going to start by introducing you to our flight team today, who will be accompanying you on your journey to the Home Office's Fantasy Island. I'm Zoe Harper, a barrister in the immigration team at Doughty Street Chambers, and I'll be chairing today. I'm standing in for my colleague Leonie Hurst, who's been called to court this afternoon. I'm joined by Camila Zapata Besso, who we were really pleased to welcome to the immigration team at the beginning of this year. Camila regularly appears in complex asylum and human rights appeals for vulnerable adults and children, and in judicial review challenges related to immigration, detention and trafficking decisions. I'm also joined by my colleague Alasdair Mackenzie, also a barrister in the immigration team at Doughty Street. He practices in all areas of refugee, human rights and immigration law, from the tribunal to the higher courts. He's recognised by Chambers and Partners as a Band 1 practitioner and is described there as phenomenal. But anyone who knows Alasdair will know that that's a total understatement. Before we take off, I'm going to start by demonstrating the technical features on board our flight today. You may have heard these many times before. You will notice that your microphones are muted and your video cameras are off. That is a pre-setting just to stop any background noise interference, and nothing wrong there. We are, however, looking forward to your questions and comments. If you have questions for the panel, I'd encourage you please to use the question and answer Q&A function at the bottom of your screens to type any questions for the panel, and that will make sure that we can see them as a panel and pick them out and answer those as best we can. If you have any comments you'd like to share with everyone on the webinar, please use the chat function, which is next to the Q&A function there on your screen below. We'd be really interested to hear your perspectives on changes in Home Office practice that you're seeing already following the introduction of the rules and guidance. So any comments and perspectives, do include those there, and we'll include those as we go along in the question session at the end. We're going to be recording this session, and a copy of both the webinar and the slide presentation will be available on Doughty Street's webinar website soon after we finish, for you or any colleagues who are unable to join us today. The format for today will be as follows. Camila will start by providing an overview of the rules and guidance and what these mean, at least as far as they can be ascertained at this stage, given the lack of detail from the Home Office. And then Alasdair is going to discuss how we as practitioners can respond to our clients' cases and the possible challenges that could be brought. We will then allow some time for questions and comments at the end, so please do send those through during the session, and any experiences or perspectives that you've had from the front line already. So without further ado, to start our journey to the Home Office's Fantasy Island, I will hand over to Camila.
Thanks, Zoe, and welcome all. I'll be taking you through the letter of the new inadmissibility procedure, its rationale, and what the Home Office guidance on the procedure says. As Zoe said, Alasdair will then be exploring some problem areas, points for potential future litigation, and will then be answering questions. Next slide. So let's start with what is the point behind the inadmissibility rules. The explanatory memorandum to the Statement of Changes, which was presented to Parliament in December 2020, says that the changes to the rules on place of claim and inadmissibility are being laid as part of the ambition to overhaul the approach to asylum and illegal migration, delivering a firm but fair system. These measures will support efforts to intensify the response to small boats and clandestine entry and lay the groundwork for new legislation next year. Now, precisely what kind of legislation the Secretary of State means by that is a chilling thought, which is yet to be seen. Next slide. Now for the real meaty part. Rule 345A on the inadmissibility of non-EU applications for asylum. This states that an asylum application may be treated as inadmissible and not substantively considered if the Secretary of State determines that, 1, the applicant has been recognised as a refugee in a safe third country and they can still avail themselves of that protection, or 2, the applicant otherwise enjoys sufficient protection in a safe third country, including benefiting from the principle of non-refoulement, or 3, the applicant could enjoy sufficient protection in a safe third country, including benefiting from the principle of non-refoulement because A, they have already made an application for protection to that country, or B, they could have made an application for protection to that country, but did not do so, and there were no exceptional circumstances preventing such an application being made, or C, they have a connection to that country such that it would be reasonable for them to go there to obtain protection. Now you'll see that I've put some potential problem areas in bold. At subsection 3b, the exceptional circumstances that could prevent a protection claim being made in a safe third country is not defined, though this will presumably include being under the control of traffickers, for example. As regards subsections 3a and b, it will of course be more difficult for the Secretary of State to discover whether someone has claimed asylum in a European country now, given that from 1st of January 2021, she has not had access to the Eurodac fingerprint database. Next, the connection under subsection 3c that would render it reasonable for an asylum applicant to go to a safe third country to obtain protection is also just not defined. Next slide. Now, the question of what constitutes a safe third country is dealt with in Rule 345b. This states that a country is a safe third country for a particular applicant if the applicant's life and liberty will not be threatened on account of race, religion, nationality, membership of a particular social group, or political opinion in that country, that the principle of non-refoulement will be respected in that country in accordance with the Refugee Convention, that the prohibition of removal in violation of the right of freedom from torture and cruel, inhuman or degrading treatment, as laid down in international law, is respected in that country, and that the possibility exists to request refugee status and, if found to be a refugee, to receive protection in accordance with the Refugee Convention in that country. Rule 345c says that when an application is treated as inadmissible, the Secretary of State will attempt to remove the applicant to the safe third country in which they were previously present or to which they have a connection, or to any other safe third country which may agree to their entry. Now, looking at these first, just to note, there is a focus on individual circumstances, acknowledging that a country may be safe for some, but not for others. The guidance states that the relevant standard applied by the third country unit caseworkers to admissibility decisions will be the balance of probabilities. Rule 345c appears to say that a person can be removed to a safe third country that they have not passed through and to which they have no connection. That is remarkable. However, they can only be removed to any such safe third country if an inadmissibility decision has been already made, which can only occur if the person has previously been present in a safe third country or has connection to a third country. However, once an inadmissibility decision has been made, removal can be to any category of safe third country and need not be the safe third country on which the inadmissibility decision was based. I got there in the end. It's worth noting here that the guidance recognises at page 5 that those who fear persecution should claim asylum and stay in the safe third country in the first safe country they reach. It is entirely unclear how that statement sits with the idea that people can be moved on to a safe third country that they've never been to and have no connection to. Next slide. Now, the exceptions for admission of inadmissible claims to the UK asylum process is under Rule 345d. And these are that when an application has been treated as inadmissible and either removal to a safe third country within a reasonable period of time is unlikely, or upon consideration of a claimant's particular circumstances, the Secretary of State determines that removal to a safe third country is inappropriate, the Secretary of State will admit the applicant for consideration of the claim in the UK. Now note that those are alternatives. The reasonable period of time for removal in this rule is not defined. However, the guidance says that there is a 6-month long stop by which the third country must have agreed to accept a person's return without explanation for that timescale. Within that timescale, examples of no prospect of removal within a reasonable timescale are given as where all possible countries of return have emphatically refused to agree to the person's return. It is not clear why the refusal has to be emphatic. The clock can also restart if the person mentions a new potential safe third country in their asylum interview. It is entirely unclear what the process and procedure will be for people to make representations that their claim should not be treated as inadmissible. The guidance states that a notice of intent will be sent to inform a person that their claim is being managed under the inadmissibility procedure, which will not constitute a formal decision on an inadmissibility, just a notification. That would suggest an opportunity for people to make representations. Indeed, the letter from MP Chris Phillip to Yvette Cooper, dated 22nd of December 2020, states that any oral or written representations from the claimant about why inadmissibility processes should not be applied in their case will be considered ahead of any removal to a safe third country. Will legal aid be available for these representations? That isn't clear. The guidance states, however, that the decision on inadmissibility will only be made if return to a third country has been agreed. It would seem, therefore, that such formal inadmissibility decisions will be rare. They will be challengeable, however, by judicial review. Next slide. Now, what about the safe third country accepting the person for readmission? The explanatory memorandum at paragraph 7.3 states that, as previously drafted, the rules allow claims to be treated as inadmissible only if the asylum applicant is accepted for readmission by the third country through which they have travelled or have a connection. It notes that a stronger approach to disincentivize individuals is needed to deter claimants leaving safe third countries, such as EU member states, from making unnecessary and dangerous journeys to the UK. Presumably here, the Secretary of State means the previous system under the immigration rules pursuant to the Dublin III regulation, which is no longer applicable, and the Procedures Directive, which has arguably retained EU law under Section 4 of the EU Withdrawal Act. Then it's paragraph 7.4. The explanatory memorandum explains that the changes separate the readmission requirement from the inadmissibility decision, allowing the Secretary of State to treat applicants as inadmissible based solely on whether they have passed through one or more safe countries in order to come to the UK as a matter of choice. They will allow the Secretary of State to pursue avenues for their removal, not only to the particular third countries through which the applicant has travelled, but to any safe third country that may agree to receive them. This means, effectively, that people's asylum claims will be treated as inadmissible, even if there is no readmission agreement at all with a relevant country, meaning the person is in practice not conceivably going to be removed anywhere. This is going to cause massive delays for an asylum process that is already plagued by delays exacerbated by the COVID-19 pandemic. The guidance states at page 5 that controlled resettlement via safe and legal routes is the best way to protect refugees and disrupt the organised crime groups that exploit them. However, an obvious question will be how these provisions interact with obligations owed to trafficking victims and victims of modern slavery. Under Article 10 of the European Convention Against Trafficking, the ECAT, the Secretary of State has, as the competent authority, is under a duty to investigate trafficking indicators and do so promptly. The duty to investigate, also arises under Article 4 of the European Convention of Human Rights and the Trafficking Directive. The UN trafficking principles and guidelines require that secure procedures are in place for the rapid and accurate identification of victims of trafficking. As practitioners will be aware, one of the pinch points in which the Secretary of State is likely to become aware of trafficking indicators is the substantive asylum interview, where applicants claiming asylum are able to ventilate the facts founding their claim. If the investigation into the asylum claim is delayed behind an inadmissibility decision, surely that will cause problems for the investigative obligation under the ECAT and Article 4 ECHR. The guidance on inadmissibility states that where the 6-month clock for the inadmissibility procedure will be paused, it states that the 6-month clock for the inadmissibility procedure will be paused to be resumed later, where a person is awaiting a conclusive grounds decision under the NRM. This seems to penalise potential trafficking victims with added periods of uncertainty in the context of conclusive grounds decisions for which significant systemic delays are going, in the words of Mr. Justice Mostyn in the recent case of EOG, from bad to worse, which will affect their prospects of recovery. Moreover, victims may be chilled from disclosing the routes they actually took to the UK for fear of being penalised by the inadmissibility process. It is also not clear how the inadmissibility procedure will interact with the possibility of victims of trafficking being granted discretionary leave, nor how the trafficking-related stop clock will interact with the rules on the exceptional circumstances which render a case unsuitable for the inadmissibility procedure. Next slide. As regards unaccompanied asylum-seeking children, be aware that the inadmissibility processes do not apply to them. However, they will nevertheless be invited to withdraw their asylum claims if certain conditions are met. See the guidance for more information on this. Next slide. Also be aware that the Secretary of State may consider cases outside of the inadmissibility procedure where they are suitable for the DAC, the Detained Asylum Casework, or NSA processes. The rationale is at page 7 of the inadmissibility guidance, which states that if a case initially assessed as suitable for inadmissibility action appears to stand a greater chance of being promptly removed if substantively considered and refused, it will usually be appropriate for the case to be routed for a substantive decision. Now, the rationale behind the prioritization of asylum claims for those who can more easily be refused and removed obviously betrays the Secretary of State's devotion to treating asylum seekers on a deterrence rather than humanitarian basis. Next slide. What about human rights claims? The guidance recognises that human rights claims may be raised either before or after the asylum claim has been treated as inadmissible. Such claims cannot be treated as inadmissible and must be fully considered. The guidance deals at page 21 with the relevant process, including the possibility of certification under Part 2 of Schedule 3. It is just not clear how asylum claims, which are managed under the inadmissibility procedure with concurrent human rights claims, which they often have, will be treated in the appeals process. It would appear at this stage that significant delays in the appeal process will also be caused. Next slide. Lastly, a word of note. There is a kind of transitional arrangement at page 7 of the guidance which states, the immigration rules relating to third country inadmissibility were amended at 11 p.m. UK time on the 31st of December 2020. These rules may be applied to claimants who claimed asylum before this date. However, in broad terms, such a decision is unlikely to be appropriate if the claimant would not have been eligible to receive a similar decision under the previous rules, or if the person's progress through the asylum system has already been substantially delayed compared to average decision timescales. Now, that concludes my presentation on the letter of the rules and the guidance. I'm now going to hand over to Alasdair. Thank you for listening.
Right, hello everybody. I hope you can see me. It's not, I'm not actually appearing on my own screen, but hopefully I am there. Somebody will buzz me if you can't. So I'm going to start with a little story. This is Dr. Mohammed Al-Masari. He was, or possibly still is, a professor of physics and a prominent critic of the Saudi Arabian regime. And Dr. Al-Masari sought asylum in the UK in the early 90s. It was around about 1994. And the Saudis, as they weren't particularly keen on this, and they put pressure on the UK government to send him back. And the Tory government, which was then in power, was aware that that wasn't going to be possible because clearly he was at risk of being tortured or killed, but nor did they really want him in this country. And apart from the fact that their friends in Riyadh weren't very pleased about him being here, there was the small matter of his somewhat controversial views, or so they were seen by the government. So between tolerating him in the UK and sending him back to be murdered, they looked for a middle way. And the middle way was to persuade the government of Dominica, in the Caribbean, of course, to accept him. And it's widely believed, although I think it's denied by those concerned, that the Dominicans were offered quite significant amounts in aid, that is, in return. But Dr. Al-Masari appealed, and in what was perhaps his finest hour, Judge David Pearl, who was then the chief adjudicator, allowed his appeal on the basis that Dominica was likely to be even less able to resist pressure from the Saudis than the UK was, and they might even decide to send him back to Saudi Arabia. And I was reminded of that story, next slide please, when Priti Patel announced proposals to house asylum seekers on Ascension Island or other offshore locations, and everyone said she was taking her cue from the Australians. So there you've got the author of our asylum system, and that's Priti Patel. Well, yes, that's correct. We were there first, and we were only prevented from taking things further because the Home Office suffered a humiliating defeat at the hands of unelected activist judges and lefty activists, lawyers, such as Andrew Nicholl, formerly of these chambers and now, of course, a High Court judge. And the solicitors, I should add, obviously pulled a blinder as well. I'm not sure who that was. I think it may have been Winstanley Burgess. Well, I apologise if I've got that wrong. So yes, the Australians, that's Tony Abbott, of course, were an inspiration, but as I say, we were there first. So now we've got a set of rules which appear very clearly not only to seek to replicate and replace, to some extent, the former Dublin provisions, albeit, of course, without the framework of an international agreement, but also to broaden things out to permit the removal of people to supposedly safe third countries, which they haven't visited and don't have any connections to. Rules which would clearly permit a modern day or contemporary Dr. Al-Masari to be removed in the way the Home Office sought to do back in the 90s. And in case you're in any doubt that that is what is meant, the Home Office's guidance explicitly envisages that, I quote, return may be arranged through a general returns agreement or arrangement with a particular country or case-by-case agreements. So this is exactly the kind of thing that they are envisaging. So what are we going to do about this? And to what extent are these arrangements, these rules, challengeable? Now, obviously, a lot of what I'm about to say is going to consist of a series of questions to which the answer is, well, who knows? Because, of course, we don't know how things are going to pan out. And as far as I'm aware, although people will correct me, I hope, in the Q&A or in the chat, no one has actually seen these provisions in operation. And there are also a number of features of the system, which I'm going to try and highlight, which make the task of looking into the future quite difficult. Next slide, please. And the first important feature I wanted to flag up is quite how vague and lacking in legal certainty this system is. It gives the Secretary of State extremely broad discretion. Many of the crucial words and phrases aren't defined, either in the rules or in the Secretary of State's guidance. So a lot is going to depend on how the courts interpret the system when it's challenged. And one reason for that vagueness, of course, is that these are not, at heart, legal rules aimed at establishing a workable and watertight, legally watertight system. They are political measures, which, just like all the stuff we had last year about Ascension Island and wave machines and goodness knows what else, are aimed at showing the public that the public is tough on asylum seekers. And the fact that these rules are likely, I would say, in their current form at least, to lead to literally years of litigation about their meaning and about their applicability in particular circumstances is not a bug, it's a feature. It's a deliberate feature of the system. The second point I wanted to make is that, of course, we don't yet have any general returns agreements or any agreements with any particular country. And as far as anyone knows, none is anywhere near being reached. Third point I wanted to make at the outset is that the rules themselves aren't consistent with the Home Office's own guidance. And it would seem to be particularly important to read the guidance rather than just the rules in understanding A, how this is intended to work, and B, what is in fact lawful. At least within the sort of four corners of the system itself, leaving aside whether the system itself is lawful. And I'd just like to highlight 3 points where the guidance doesn't appear to be consistent with the rules. First of all, the rules say that an application may be treated as inadmissible once the criteria in the rules are met, e.g. that a person has got asylum or has claimed asylum or could have claimed asylum in another country, etc., etc. And they don't say anything about whether the person has actually been accepted for removal by that country. Indeed, the explanatory memorandum to the rules, if you look at that, it's also on the Home Office's website, says that the new rules, quote, separate the readmission requirement from the inadmissibility decision, unquote. But the guidance says the exact opposite. The guidance says that an inadmissibility decision can only be made if a readmission agreement in the individual case has been reached. So there's a clear contradiction there between the rules and the guidance as to whether an actual agreement from the proposed receiving state is needed before a claim can be treated as inadmissible. Second point of inconsistency, the guidance says that children are not suitable for inadmissibility decisions. Well, fine, that's obviously a good thing. And it's far from obvious actually how the best interests of a child could be respected by putting them into this, what appears to be in many cases a long drawn out process. But the rules don't actually say that. And it's not entirely clear why not. The rules don't actually exclude children from the provisions. The third point is that the guidance regards a 6-month delay as the maximum reasonable period in most cases. It's referred to in the guidance as a long stop, as Camilla's just said. But again, that doesn't appear in the rules either. And there are other differences. Those are just the main ones I wanted to flag up. Now, against that background of uncertainty and inconsistency, what are the remedies that people might be pursuing? Next slide, please. So first of all, appeals. Now, you might think that a decision to treat an asylum claim as inadmissible is not itself a decision on that asylum claim. Indeed, you might think that's the whole point of the system. But it seems that you would be wrong if you thought that. And I should just say that's an indication of quite how convoluted the system is and how far it strips words of their actual meaning. It's not in reality that people's claims aren't being admitted, it's that they're being refused on a basis other than that they're at risk in their country of origin, sorry. But of course, talking about admissible or inadmissible claims sounds tougher. In fact, I think it seems pretty clear that if you've made a protection claim, i.e. you have claimed that your removal would breach the UK's obligations under the Refugee Convention, and the Secretary of State has said, no, those obligations would not be breached, then the Secretary of State has refused your protection claim. And that's an appealable decision, it would seem on the face of it, under Section 82 of the 2002 Act. It's also clear that if you've made a human rights claim, and of course, most asylum claims will almost inevitably include either explicitly or implicitly an Article 3 claim, an Article 8 claim, quite possibly an Article 2 or an Article 5 or an Article 4 claim. If you've made one of those, if you've made a human rights claim, then that can't be treated as inadmissible. That has to be considered. And again, both the rules which don't cover human rights claims and the guidance more explicitly say that. That said, the human rights claim would only be considered, it seems, insofar as the Secretary of State would say, well, there would be no breach of your human rights because of another country to which you can be sent. So the outcome is likely to be the same. And of course, I should just add that some people, of course, may have human rights claims based on private or family life in the UK, which would be appealable if refused, unless they're certified as clearly unfounded. And it seems pretty clear that the Home Office accepts this, that these are appealable decisions on the face of it, because quite a lot of their guidance is devoted to appeal rights. But, and of course there is a but, the Home Office envisages certifying people's claims, in most cases, under Schedule 3 of the Asylum and Immigration Treatment of Claimants Act 2004, so as to either deprive them of any right of appeal or deprive them of an in-country right of appeal. Section 3, of course, contains the existing provisions for certification of claims on human rights, on third country grounds. And those still exist, even though the EU framework in which they were enacted has gone. And it seems pretty clear that the Home Office is going to try and apply them, at least until any further legislation is put into place. So in most cases, your remedy in the individual case is going to be JR, as Camila has already said, either JR of a decision to treat the claim as inadmissible, which amounts to a decision to refuse the claim, and or a decision to certify so that you don't have a right of appeal, or a right of in-country appeal. Next slide, please. And obviously, you bear in mind that, at least as far as the guidance is concerned, as I say, the rules say something different, but at least as far as the guidance is concerned, you have reached this point only if the country in question has in fact agreed to accept you. And your potential grounds of challenge will inevitably include the traditional grounds in third country cases, i.e. that it's not safe in the country in question, or that that country will further refool you to your country of origin, or that it won't effectively admit you to its asylum procedures. And no doubt those challenges will be strongly influenced by the existing Dublin case law on which countries are safe and on what basis safety is to be determined. Note, however, that of course the UK no longer has access to Eurodac, so deciding whether a person's actually been in a particular country to which they might be removed is less straightforward than it was. And you might also, of course, be challenging an assessment by the Secretary of State that you were in fact in that country. Although, of course, if that country accepts that you were there, you might face some obstacles in challenging it. You might also be challenging the decision that you've got a connection with that country sufficient to make it reasonable to claim asylum there. That's paragraph 345A3C. Now, of course, that idea of a connection such that it's reasonable for you to claim asylum there is so broad as to be almost impossible to define. What are we talking about here? Are we talking about people with citizenship there? Well, you know, that might be arguable, but, you know, are we talking about people who've got partners with citizenship there? Are we talking about people who've got relatives living there as under Dublin 3? Are we talking about people who've just studied there 20 years before? You know, what is being talked about here? And the guidance is entirely unclear on what the Home Office is envisaging there. And as I say, again, you need to bear in mind that agreement from the country in question needs to be achieved. So that country might, of course, take a very different view from the Home Office about what is reasonable in terms of a connection, meaning that you should seek asylum in that country. Alternatively, you might be challenging a decision to return you to any other safe third country which may agree to your entry, 345C. As Camilla's explained, that's a criterion which only arises if your claim is inadmissible on other grounds. So once you've been treated as inadmissible, that opens up a whole vista of countries to which you could be removed, to which you don't need to have had a prior connection, you don't need to have passed through, etc., etc. Secretary of State can't treat your claim as inadmissible simply because there is any third country somewhere in the world which might accept you. But once they've treated you as inadmissible, once there's an identifiable country falling into one of the categories identified in the rules, the range of countries to which you could potentially be sent is much broader, and as I say, covers countries to which you don't have a prior connection, you haven't passed through. So that's what some people, or at least me, have called the Fantasy Island provision, which permits the Home Office potentially to send you to any country in the world which will take you. And obviously the challengeability of any decision like that is going to depend on a huge range of factors, which we just don't know yet. You know, what conditions the person's going to encounter there, whether they'll be safe from persecution there, whether they'll risk onward refoulement. Obviously that's the basis on which Dr. El-Masari succeeded in challenging removal. And of course, you'll bear in mind that the country needs to be safe for the individual. Paragraph 345B says safe for a particular applicant. So it's not just about whether the country is safe on a generalized basis. And also, of course, if you make a human rights claim based on, for example, just to raise something which comes up quite a lot, on, say, your need for mental health care or your need for rehabilitation following torture, which might not be available in the country in question. You know, mental health services on Essential Island probably aren't what they are here in London. That might also form the basis for a challenge. Next slide, please. So at what point do you get to make representations on your third country removal? Obviously, it seems unlikely that the Secretary of State could make a lawful decision, a decision which is lawful in public law terms, to remove you without giving you the opportunity to explain why you shouldn't be. And the notice of intent stage, which is the stage where the Secretary of State writes to you telling you which countries are under consideration as a destination, would seem to be the obvious point for making representations. And the guidance does require the Home Office to consider any representations received. But oddly, you might think there is no reference to inviting representations. And the standard wording which appears in the guidance for the notice of intent letter doesn't actually tell people they can make representations. And if the applicant doesn't know because they haven't been told, that they can resist removal to a third country. And if the applicant, of course, doesn't know what criteria the Secretary of State is going to apply, then it's not really very obvious that the Secretary of State can make a lawful decision, particularly, of course, if there's then no in-country right of appeal on the merits. Could you challenge the notice of intent, i.e. the decision to investigate the possibility of third country removal? Well, the Secretary of State's guidance says the notice of intent is not a decision. Well, fairly clearly, I would have thought it is a decision. It's not a decision on the outcome of your claim. It's not an appealable decision in that sense, but it is a decision on how to process your claim. And therefore, it's potentially JRable, you'd have thought. Just as, for example, a decision to park your case without deciding it for 2 or 3 years would be a JRable decision. And of course, it seems perfectly plausible that if the Home Office doesn't have any real basis for thinking that third country removal might be possible in your particular case, for example, because the evidence of having been in a particular country is too tenuous, or because there's no realistic basis for thinking that any third country removal would be possible, then you could challenge the decision to put your case effectively on hold while the Secretary of State investigates something which doesn't really merit investigation. It also seems to me quite likely that the Home Office would have to show that they're making progress with these investigations and not just sitting on their hands. And I think the danger, and anybody who's sort of observed the Home Office for any period of time will recognize this, the danger is that what's supposed to be a kind of discretionary and fact-specific investigation in which 6 months is described as a long stop actually kind of hardens into a system where basically everybody's case gets bunged in a filing cabinet for 6 months while literally nothing is done to advance matters. And we've all seen that in detention cases, for example. And even if somebody isn't in detention, you'd have thought that by extension or by parallel, the kind of Hardiel-Singh type case law about how long it's reasonable to detain somebody, how reasonable, how realistic the prospect of removal needs to be, could be of assistance in deciding what's a reasonable time to consider admissibility. Next slide, please. And broadening it out to look at the system as a whole, is there a possibility of systemic challenge? Well, again, there are 3 points I'd just like to highlight at this stage. The first is the idea that up to 6 months is likely to be a reasonable amount of time for the Home Office to be pursuing admissibility. It's not obvious where that's come from. It seems to have been calibrated as the sort of period of time which the courts might be reluctant to interfere with, you know, the sort of period of time which the courts might say, well, you know, it's only 6 months. But certainly at the stage where there aren't any readmission agreements in place at all, it's really not obvious that a system which routinely places cases on hold on the basis of what might be very speculative beliefs on the Secretary of State's part in the possibility of third country removal, it's not at all obvious that that's a rational system, it seems to me. The second point, potentially linked to that, is compatibility with the Refugee Convention. Now, there are a number of aspects to that. The rules do seem to have been designed to comply with what's often regarded as the key right under the Refugee Convention, namely the prohibition on expulsion or refoulement, as it's called, under Article 33. And that's why the rules talk in terms of threats to life and liberty. Of course, those are words taken directly from Article 33 of the Convention. And I mean, I think that's probably right. I think it's probably not inherently in breach of Article 33 to have a system which envisages removal to a country where you would not be at risk. But there may be an issue about whether effectively preventing people from having access to a determination process breaches their rights under the Refugee Convention. And you'll recall, of course, that the Convention applies to anyone who meets the definition of a refugee, being outside their country of origin and having a well-founded fear of being persecuted for a convention reason, etc., etc. And once that definition applies, you've got a range of rights which are not limited to protection from expulsion, but also cover various social rights, such as rights to work, claim benefits, etc., etc. And of course, refugee status is declaratory. You are a refugee because you meet the definition, not because a state decides that you're a refugee. And of course, Section 2, as it stands, Section 2 of the Asylum and Immigration Appeals Act 1993 prohibits the Secretary of State from adopting immigration rules, which would obviously include these rules, which are inconsistent with the Refugee Convention. And it's partly because failing to make a decision on someone's asylum claim deprives them of the opportunity to exercise their Refugee Convention rights, that the courts have said that there needs to be effective access to a determination process in which decisions are taken within a reasonable time. A good example would be the case of Saad Diriyeh and Osorio in 2001, for example. So would the courts be sympathetic to an argument based on systemic failure to examine people's asylum claims? Well, possibly. I mean, I'm a little skeptical because, you know, if one looks at the difficulties which were encountered in bringing a systemic challenge to delays in the NRM recently, or going back to systemic delays in the legacy programme, there's a lot of tolerance in the courts for the Secretary of State's lack of efficiency and lack of promptness. So it may be that challenges would need to be more based on particular facts of individual cases or of particularly vulnerable groups, and on a need for flexibility and individual consideration. That is to say, obviously, delay, which could be reasonable in one case, might not be reasonable in another, depending on the individual characteristics of each person and on the relative likelihood of removing them. But, you know, I wouldn't want to sort of rule out before it started a possibility of systemic challenge on that basis. And the final point I just wanted to make is the idea in the guidance that certain people, particularly victims of trafficking and modern slavery, can have the admissibility process placed on hold while their trafficking claims are considered. Now, bearing in mind that the admissibility process itself places your asylum claim on hold, it's very far from clear why it's considered reasonable to place the admissibility process on hold and thus place your asylum claim doubly on hold while the Secretary of State's investigating your trafficking claim, which, you know, we know can take months or indeed years. Why should you be penalised with an even more extensive degree of uncertainty over your future because the Secretary of State takes ages over your conclusive grounds decision? You know, what, for example, if you're merited to deem discretionary leave for purposes of your recovery following your trafficking experiences? You know, we're not told. The guidance is silent on that. But the applicability of this entire process to victims of modern slavery and trafficking seems to be at least open to question. Final slide, please. So that's all I wanted to say. You've been sending in your questions by the chat, and I think that Zoe is going to field those, and we're going to try and deal with them as far as we can.
That's brilliant. Thank you so much both for your presentations, which are absolutely chilling, and the information they provide. We've had lots of questions, so I'll try and group them to get through as many as we can. The first is around detention. Tom asks, how and what case law can the Secretary of State use to keep people in detention while this process is ongoing? But actually that invites a pre-question, which is, you know, whether the Secretary of State will detain people during this process, and if not, will people be entitled to asylum support in the usual way? If I could maybe ask Camila to address those two questions.
Zoe, I think I can address them both quite shortly. In my view, there's no reason why detention wouldn't be appropriate for somebody whose asylum claim is being managed under the inadmissibility process. And indeed, the use of the words reasonable timescale within the rules and within the guidance seems to presuppose or expect that people will be detained while they are considered under the inadmissibility procedure. As regards asylum support, I mean, this isn't clear, but my reading of Section 95 is that upon the asylum claim being made, asylum seekers will be eligible for asylum support, even if their asylum claim is not strictly being considered because it's being managed as inadmissible. Thereafter, if the asylum claim is refused, they'll be eligible for Section 4 protection.
Thank you very much. There were a couple of questions around Dublin and transitional measures for where people were previously dealt with under Dublin, and perhaps removal was halted through litigation, but also a similar question around where a third country decision has been made and not yet removed, would they be caught by this new admissibility regime in your view, including where it's been more than 6 months since? And that was for Camila too. I think I flagged that one up for you, having dealt with the transitional points.
Thanks, Zoe. Well, I assume as the UK is no longer subject to the Dublin III procedure, third country removals cannot be exercised. But be aware of the transitional type arrangements in the guidance, which do imply that inadmissibility decisions, which remember do not actually require a readmission agreement, may be appropriate for persons who had been eligible to receive similar decisions under the previous rules. However, that it won't be appropriate where the person's progress through the asylum process has already been delayed compared to average timescales. I think that answers to some extent the question as regards cases that were previously being considered under the Dublin III procedure and those for which there has been a significant delay. But I think we will just have to see how these arrangements play out in practice in the future.
Thanks, Camila. So for Alasdair, any additional perspectives, but also I wanted to take you to paragraph 345D2. Ray, that's slide 6, if you have an opportunity to pull that up. And that's the, to respond to Christina's question about the vagueness of that rule. That's the rule that refers to an application being inadmissible if removal to a safe third country within a reasonable time period is unlikely, or if the Secretary of State determines removal is inappropriate. She mentions that sounds very vague. Of course, what are the criteria? What are your perspectives on that as a sort of vague statement of?
Yeah, no, absolutely, it is vague. I think the question was specifically about the circumstances in which the Secretary of State might determine that it's inappropriate to remove you. Now, you'd think that those would have to be slightly wider than just human rights considerations, but it seems that there are, no limits, but also no criteria on what might be appropriate or inappropriate as far as the Secretary of State is concerned. Either they're going to have to put in place more detailed guidance, or we're just going to have to go to court all the time and get the courts to tell us. One example I would have thought could be the kind of scenario that I flagged up in my presentation. For example, if you need rehabilitation from having been tortured, for example, you're receiving medical treatment or counselling or whatever it might be in this country, and it's not going to be available, or breach your therapeutic relationships or something like that. You'd have thought that would be the kind of situation you might be looking at. But, the answer is, really nobody knows because they're not telling us.
Absolutely. Julian asked a very practical question about how might the Home Office treat a no comment screening interview given by a claimant where the claimant refuses to divulge exactly how they've travelled to the UK. Do you have any thoughts on that?
Me?
Yes.
Yeah, also, like Christina's a great question. You don't have a right to silence, do you, in an asylum interview? And you would have to take the risk, I would have thought, that the Home Office is just going to say, well, you're deceiving us, you're lying to us, and that anything you say or refuse to say will be taken as an indication that what you say in your asylum claim isn't genuine. I think that's the truth of the matter. On the one hand, they can't force you to say anything. On the other hand, you'd clearly have to take the risk that failing to assist would be an issue they could raise against you as regards credibility. Would probably fall within Section 8 as well, wouldn't it? The credibility provisions. So, I think one would have to think long and hard about giving somebody advice not to answer questions like that. But equally, there may be circumstances where it would be in their interests not to answer. It is a case, and the Home Office's guidance recognises this, that in the absence of access to Eurodac, they've really got no way of knowing. Unless you turn up with a bus ticket from Paris or whatever, they've really got no way of knowing where you've been unless you tell them, you know. Yeah, it's not an easy one to answer, and one would have to be very careful, I think.
Another question about the process, which is, do we think these new rules are likely to be applied retrospectively to those still awaiting an asylum interview, so currently in the process? And Simon asked that because, you know, as we all know, the many clients' cases have been delayed for 1-2 years or more. Camila, I don't know if you want to respond to that, or both jump in.
I'm so sorry, Zoe. My my audio cut out just when you were asking that question. Could you repeat it?
Yes, so it's about whether we think the new rules are going to be applied retrospectively to people awaiting an asylum interview. We know that there are many people in the current system who've been waiting 1-2 years or more. Do we think that's going to be applied retrospectively to them? And also to another question also asks about application retrospectively to others arriving pre-31st of December.
Well, as I've said in relation to the transitional type arrangements mentioned in the guidance, but not the rules, I think this is yet to be seen. I mean, there is an acknowledgement in the guidance that the inadmissibility procedure will not be suitable for asylum claimants for whom the consideration of their claim has already been significantly delayed according to ordinary timescales. I don't know what those timescales are in the Home Office's mind, and I think we're just going to have to see what the Home Office starts doing in due course. Unfortunately, the position in that regard is still really vague and unclear. Thank
you. Sonia very helpfully points out that in terms of legal aid, the wording of the relevant paragraph, Schedule 1 to LASPO, is very broad. And so taking that into account, would there be any reason for thinking that legal aid won't be available for making representations in connection with admissibility? Again, for practitioners, a really practical question, you know, in terms of supporting our clients in this process.
Me or Camilla?
Just jump in with perspectives.
Yeah, I mean, obviously, far be it from me to disagree with Sonia. I noticed that Paul Keeley has made the same point as well, and far be it from me to disagree with Paul either. Yeah, I know I'm, you know, for my own part, very, very happy to defer to the experts on the availability of legal aid. Shall I just deal with the question on Section 95 support as well?
Yes, please do.
Yeah, my understanding from having spoken to colleagues at the Asylum Support Appeals Project is that the Home Office think that Section 95 support is available up to the point where the inadmissibility decision is made. And after that, Section 4 support would be available. And I think that's probably right. If you look at, you know, if you treat the asylum claim as a claim which has been made, even if it's being treated as potentially inadmissible, it's still an asylum claim for the same reason that you've got a right of appeal, potentially. It's an asylum claim which attracts a Section 95 support if you're otherwise eligible. So I think that seems to be the Home Office's position, and I think that's probably correct. So Section 95 up to the point of the inadmissibility decision, and Section 4 thereafter.
I think you were also going to discuss the point that's come through to us directly on the chat from Nick at the Irish Refugee Council. This might be a good moment to flag that. He's mentioned that the UK is now deemed a safe third country in Irish protection law, and the inadmissibility definition there has recently been expanded to use the same language used in UK law. Any thoughts or perspectives on that very interesting point there?
Yeah, it's a very interesting point. I mean, a lot of people, I imagine, will be, you know, expressing hollow laughter at the idea that the UK is a safe country for anybody, given events in Napier Barracks recently, for example. But yeah, I mean, obviously, it's a real issue if other countries are taking their lead from the UK in adopting these kind of provisions. And you do wonder whether the Home Office have actually thought this through. We don't wonder if they've thought it through, do you? Actually, they quite obviously haven't. But it's if all the countries in the world are going to start sort of trying to foist their asylum seekers off on each other, if you'll forgive the expression, it's not really productive of good relations, and it's clearly not in the spirit of the Refugee Convention. The Refugee Convention is supposed to be about the international community stepping in to support people who need it, and states sort of acting on behalf of the international community to protect people, and refusing to take responsibility for people, and countries around the world seeking opportunities to sidestep their obligations is at the very least not in the spirit of the convention.
Absolutely. There are a couple of questions around whether we're aware that any agreements with other countries are in place to receive people returned from the UK, and then how likely it is that a third country, either in the EU or elsewhere, would agree to take in asylum seekers sent as inadmissible claimants from the UK. Are either of you able to comment on those questions?
Sorry, whether there are any agreements in place?
Yes, whether there are any agreements in place, and also how likely we think it is that a third country will make agreements or take on asylum seekers from the UK. Again, without those reciprocal Dublin arrangements no longer being in place for EU, for example.
Well, as far as I know, there's nothing. I mean, people are, I'd be very happy if people were to sort of flag up on the Q&A or in the chat if they're aware of any, but I'm certainly not aware of any. The Home Office's guidance doesn't refer to any. So I think the answer has got to be no. I also think it's quite likely that we'd have heard about it. They'd have been broadcasting it all over the newspapers if they had. How likely? I mean, who knows? I mean, I can't really see why it's in the interests of any EU state to put in place this kind of arrangement with the UK. Why would they want to, really? As to, small islands like Dominica, well, it may depend on how much cash they're offered, frankly, as with Dr. Al-Masari. But, those are political questions.
Absolutely. We're coming to time. Is there anything else that either of you'd like to add, or that you perhaps spotted in the questions that I haven't? Because obviously there's a lot that have come through, so I apologise to anyone whose question I've missed. But any final comments before we end this afternoon? It has been, It has been an extremely comprehensive overview, and I'm really grateful to both of you for providing that analysis and perspectives, and also ways forward. Just want to thank you again, and everyone who joined us today, and for your questions and perspectives, which have been really helpful. I'll just finish by reminding everyone that the webinar and slides will be available on Doughty Street's website soon afterwards. And thank you very much for joining us on our flight to Fantasy Island today.
Thank you, everybody. Do feel free to email us, or, well, I'm speaking for Camila, but certainly feel free to email me, and I'm sure her as well. If you'd like any questions answered, we'll do our best.